I swear to God, it's not me.
No.
It's
The tattoos and the pictures or your tattoos?
My sister.
So it was you. We can drop the act. I gotta have you put your hands behind your back, okay?
What's going on?
You're just detained right now. I guess I could try and...
Reno, Nevada, I, 28 de agosto de 2023. What starts as a routine trespass call at a Costco quickly reveals 3 distinct constitutional issues, and one voluntary statement that hands prosecutors a second charge on a silver platter.
So this the guy that pulled the knife on me?
It's him?
It's his girl that was in here that we couldn't
girl.
find. She came back in and she's at the membership counter. She is walking out right now.
Okay. We'll have a chat with her then. When was the last time you trespassed her? Okay. Did you tell her specifically, or was it just she was put on your bar? Okay. No problem. Ma'am, excuse me.
Yeah.
Hi.
Hi.
So, it sounds like you've been previously trespassed from here, okay?
I've never been trespassing here.
Okay, well then we're going to advise you today, okay? Can I get your ID real quick?
Yeah, why am I trespassed?
The business doesn't want your business.
There was an incident on July 8th of this year.
My
with
sister.
You and another
It was
gentleman.
not me. I had a twin
The
sister.
tattoos
I
and the
know.
pictures or your tattoos? It's you.
What tattoo?
The rose tattoo on the back of your arm, all the tattoos line up.
We just came. I swear to God, it's not me.
No,
but
it's
okay.
you.
Well,
I remember
here's the
because
thing,
I was
ma'am.
the one that dealt with you.
But you weren't because it
Yes,
wasn't.
I was. You
Yeah.
refused
I
to
understand.
use
I'm not
that.
a
Here's the
toucher,
thing, though, okay? Here, can I have your ID, please?
I mean, I didn't do anything wrong.
It's to identify you for a trespass.
And you
Okay.
concealed 6
You're
bottles
not-
of Hennessy in your
You're
purse.
not getting in any trouble right now, okay? So, just...
But what do you say right now, though? But you can't describe it for me. You can't. You really can't.
Okay, well, here's the thing. You have a duty to identify.
I do.
Okay?
Go ahead.
You're being
Yes.
detained.
I just don't want to be too worried.
Okay.
I mean,
That's fine.
thank you.
So, here's the thing,
Because
okay?
he was just going to let me go pay for a membership. Like,
So, here's the deal, okay? So, any business in the state of Nevada has the right to refuse any customer for any reason that doesn't qualify as the protected classes. Race, religion, creed, sexual orientation, so on and so forth, right?
yeah.
Okay? So, none of those are met. So essentially, if you came in and they said nobody's allowed in here with rose tattoos on their arms,
I got you.
that means they get to refuse your service, okay? And part of that is they believe that you were involved in an incident on July 8th, okay? That's on their end, okay? They feel as though you committed a crime here, okay, or something like that. I'm assuming it's for like a petty larceny or something like that. Okay, so they assume that that happened. Therefore, they want to they're reserving their right to refuse you service for here and into the future, okay?
Okay.
So, from here on today, okay, you're going to be trespassed from here. You can't come back within 6 months, all right?
But after 6, okay.
After 6 months, you can try and come back, but then they may just re-advise you of trespassing, okay?
Okay.
And at the end of this, you're going to send 274.
He's just going to let me pay for membership.
Can I get a 29 on one, please? You just paid for your membership or
He
no?
was just about to let me go do it. I just...
Okay. Yeah, and I don't know.
And it's $120, so I was like, I was going to go pay him right now, but...
Sounds like you get to save yourself 120 bucks.
Yeah, thank you.
I can't think of anybody who doesn't want to save themselves 120 bucks.
I said I got it everywhere.
I know, I saw it.
I got it everywhere.
You're just going to have to take the plunge, I think.
It's all right.
Good.
I know I have a ticket, but that's the only thing I have in my name, like, to do with incomplete. I have a ticket, but I have to... That's nothing. I'm just making payment.
Copy, thank you. Go ahead and confirm, please. Okay, so, I'm sorry, I missed that because they were talking to my ear.
Oh, I'm sorry. I was saying I know I have a ticket that I make payment, but that's not. It's just coming up.
You make payments on the ticket?
Yeah, $25 a month.
Oh, okay.
Yeah.
That shouldn't be anything.
Okay. It's just a traffic.
Just a traffic thing? Yeah. Okay. Do you know where it was from? Who gave it to you?
Court?
No, sorry. Who issued the ticket in the first place? Reno PD, Sparks, Washoe, NHP, Tribal.
Sparks?
Sparks, maybe?
Yeah. I believe, yeah.
And how long have you been making the payments on them?
I think I made one payment, 2 payments. It's once a month.
Oh, okay.
Yeah. So,
Okay.
yeah.
I was just curious.
Why am I okay? Is something wrong?
I haven't gotten it back yet. I just heard you mention it, and they were chatting to me, and I had to confirm some of the information.
Okay.
So that's why I wasn't able to hear what you were saying. So I was just trying to.
Thanks for being so nice. I just,
Yeah.
they were helping me shop at the clothes because I came to get my grandbaby the outfit.
So what it sounds like is that there was an incident previously. I don't exactly. I think they said it July 8th or something like that, where if you're saying you have a twin sister or whatever or what, I don't know. Maybe it was her. Maybe it was you.
I think it was her boyfriend. She said something about her boyfriend coming with her and not being able to come back. But when she came back home that day, she didn't even have him with her. So. But that's the only thing I heard about Costco. So.
Okay. And what's your sister's name?
Erica. But yeah, but see, like, this one's not even done. And that's why I was like, no, there's no way, because this one, it's even a little bit here, and it'll be finished. I just didn't want to go, but when he stopped, I didn't want to go have him finish it.
So you're working on that one now? Is that what you said?
Yeah.
It's got to be expensive, huh?
Yeah, they're doing it per sitting, so it's $100 per sitting.
Oh, that's not bad.
No, but I have to wait.
Well, yeah, you have to wait for it to heal.
And I have to wait for the money, so.
Wait for the money?
Yeah.
Where do you go to get your tattoos?
It's actually my sister's cousin. Not her cousin, her boyfriend's cousin, but she's marrying his ass, so it's her cousin.
It's your boyfriend's cousin or cousin?
No, her boyfriend's cousin.
Your sister's boyfriend's cousin.
It's Auntie's uncle's sister, but it's next door neighbor. Actually, my bride home. Either left to go get them from work or hopefully they come back home.
Well, I mean, it sounds like you're on the hook for a ride, right? Because you don't have a driver's license, you can't be driving.
I have an ID, yeah. Well, you know.
Yeah, I saw it, that it was just an ID card only.
Yeah. Because there was a red car right here when I was walking out, so I was trying to walk through, but they were like going away. I'm like, don't leave.
Okay. Copy. Okay, Crystal. I gotta put your hands behind your back, okay? You're just detained right now.
Oh, do I have a car?
Yes.
Can you take this over there?
I will take this. I gotta walk you over to my car.
Yeah, can you go over without this happening?
Because it's all about me controlling the situation, okay? I don't want you to run or fire or anything. I want to believe your promise, but people take advantage of us in our time to have fun, so. It's
Loss
out of
prevention identifies the subject through a tattoo, matching photos from an incident 7 weeks prior. Under Terry versus Ohio, an investigative detention does not require probable cause. A physical characteristic corroborated by a witness is sufficient, reasonable, articulable suspicion to justify the stop. The officer requests identification. Crystal pushes back. Nevada Revised Statute 171.123 is unambiguous. A lawfully detained person must identify themselves. That obligation is triggered at the moment of detention, not at the moment of formal arrest. Refusing to provide ID here is not a legal option. The officer explains the business's right to refuse service, and every word of that explanation is legally accurate. Under Nevada law, a private business may deny entry for any reason that does not target a protected class. A prior incident on the premises, even without a criminal conviction, is a valid and sufficient basis for exclusion. Crystal attributes the July 8th incident to her sister. One critical detail: Miranda has not been issued yet. Statements made during investigative detention cannot be compelled, but if volunteered, they are fully admissible in court. Crystal is speaking freely. Every word is on the record. The officer initiates a warrant check through dispatch. Running a warrant check during a lawful detention is constitutionally permissible without additional justification, provided the detention is not prolonged beyond its original purpose, as established in Rodriguez versus United States in 2015. Dispatch confirms an active arrest warrant. Sparks Municipal Court, contempt of court. Under United States v. Watson, a confirmed, valid warrant. Provides complete Fourth Amendment authority for a custodial arrest. No independent probable cause is required. The warrant itself is the authorization. Handcuffs go on. The legal threshold has fundamentally shifted.
It's out of Sparks for contempt of court.
Oh yeah, that's that could be $25 a month.
It doesn't sound like it. They're gonna confirm it. So right now you're just detained, okay?
Okay, but I'm not under arrest.
No.
Can I make a? Yeah, I got you. I know.
I can have you make a phone call on speaker.
Yeah.
Once we figure everything out, we'll walk my car's in.
If they confirm that that's it, then
If they confirm it, yeah, then you'll be under arrest and I'll have to take you to jail for the warrant.
okay.
Doesn't sound like any additional trespassing at the moment.
No,
I've got
yeah,
to
I
talk to
don't
them
have
and
nothing
figure
like
that
that.
out. And I'll have you take one big step to your left.
Oh,
Upper left.
sorry.
That's all right.
I'm just upset.
All right, go have a seat. And then watch your leg. All right.
7th and build. Blue shirt. Associated vehicle is going to be a blue Ford Explorer 793X33.
Okay. So, I got some other things I want to talk to you about. Okay, it's not related to this.
Okay.
But because you're sitting in the back of my car, I got on this monkey suit, you're in handcuffs. I got to read you your rights so you've seen all those cop shows, Law and Order, Life TV, all that good stuff, okay? So I just want you to listen real carefully, and then I'm going to ask you a couple things at the end, okay? So you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer. If you cannot afford a lawyer, one will be appointed to represent you before any questioning if you wish. Does that all kind of make sense? Okay. So what I wanted to talk to you about was, I wanted to talk to you about the July 8th incident that they're referencing. Okay, so I was here when that happened, and they got some pictures of who was involved. Okay, and the tattoo matches exactly. All right, and I have tattoos, so I know that this is not fresh.
This is fresh.
Well, fresh is a relative term, but it's not fresher than July 8th. It happened then. So you came with another gentleman, okay, and you guys went in there. Something happened. You guys, whatever. He did his own thing, okay, and took off out of the store. Then they came and they found you, and they asked you for your membership card, and you gave them a membership card that didn't belong to you. And then they asked you to leave, and you left. They wanted to look inside your purse because they felt that you were concealing items, mainly bottles of liquor. And then you denied that and had a rag laid over the top of it. And then you walked out and you went to your car and I grabbed pictures of you on the way out. Okay? And I'll venture a guess to say that you have 2 tattoos right here on your collarbone. Okay, so it was you. We can drop the act.
I'm not acting. I mean, I thought if it wasn't that time, but I'm not acting.
Okay, well, the act, the lies, whatever. Because you said that that was your sister that was involved here. And you said the only thing that you heard about was that reference to the Costco was your sister and her man came here and there was something. Okay, so it wasn't your sister and you know it wasn't your sister. And you remember exactly what happened.
I don't. Only because, and that's not it. It's because, I mean, you can think that I'm lying still, but I'm not. I'm not bringing this part. It's because I was actually heavily medicated, but it's fine.
Heavily medicated?
Yeah.
Alright. Hang tight for me, okay? Yeah, if you just want to keep an eye on her real quick, I'm going to talk to her. Because I don't know if you were there that day, but a long time ago there was a robbery with machete here. So I took that case. We found the guy. He's, I think, still up at par right now. But she was with him when it happened. I just remember it was busy as all hell that day. Because I pretty much was working just
like today?
Yeah, just like today. Alright, So I pulled up the pictures that we took, or that you guys took for the previous time. Do you remember if you like actually formally trespassed her?
I don't believe we formally trespassed her. So
Okay.
this would be
That's-
the first technical instance.
Okay,
of it.
sounds
Yeah.
good. And I just did it on your guys' behalf.
It
and
was more
watched
so like what happened is like we asked her to open her bag because it was clearly that she was concealing something.
Yes.
Obviously, we're not going to obviously force it.
Did you guys have an opportunity to review footage to see if she actually did?
We did, and I don't believe our LP was ever able to like verify, something like.
Okay.
And I think he was able to get footage of the gentleman, but I believe he was apprehended because I got subpoenaed for that.
Yep.
So,
For next week?
yeah.
Yeah, that'll be the grand jury for him. I found out he was 5 times prior convicted felon.
Holy shit.
So I asked the DA to pursue habitual, which I think 374. Okay. So there is that for you. And since you weren't able to confirm, nothing we can do about the previous time. I listed her as involved because it sounds like somebody, with those pictures that you got, somebody recognized her in her tattoos and identified her at the time. So I think I gave you guys the information before when I was last year when I was picking up the video.
Yeah. I think that's why I remember. That's why when I saw her, I was like, I'm pretty sure he said that they had like a warrant out for her or something. Someone was looking
Yeah,
for her.
potentially. So that's all of her stuff. Just keep that. Keep it on. Let all your people who do this kind of stuff out there. Let them know. And this will be logged as well that she's being trespassed.
Cool.
Okay.
Awesome.
Yeah. Have a good rest of your night, and I'll see you next week, I guess. All good. Yeah, just gonna transport her. Okay, Crystal. So now you are under arrest and you're able to confirm your warrant. It's for contempt of court out of Sparks. So I don't know if you got a ticket from Sparks and you were supposed to pay and do community service or whatever. Okay, yeah. If you're delinquent on those payments or something like that, they'll usually hit you with contempt of court because you made an agreement with the court and you're not sticking to the agreement. So that very well could be. I don't know. I'll be able to get more information about how much it is. Yeah, I just mean like how much the bond is or bail or the amount for the warrant, yada, so on and so forth. Okay. Do you have anything in your bag I need to know about?
Yeah, I need 2 bottles.
2 bottles? From here?
From here?
From here, yes? Okay.
Thanks for doing your job. At least we're not in California, right? Where they just...
Yeah, exactly. Thanks. You have a good rest of your night. Do you have the ability to let me inside or get somebody out here?
I don't have a walkie or I don't have a radio.
Damn. I guess I could try and knock. Hopefully that works. Yeah, I started here at Reno.
Nice.
Yeah, I went right out of college, so
What did you major in? Criminal
criminal
justice?
justice, yeah.
Did you go to UNR?
Mm-hmm.
Nice.
Yeah.
That's pretty cool.
My God.
You want to sign a complaint for it? She said she got him from you.
She just threw her in her bag.
Because I asked her, I said, I was like, is there anything I need to know about in your bag? She says 2 bottles. I'm like, 2 bottles for what? She's like, a liquor. And I said, from where? She said, from here.
Yeah, full court press.
If you want, can you grab a blank receipt of those?
Yep.
How much it is? And then if you just want to meet me out in my car, because I need to have you sign out.
All right, I'll be right back.
All right, sweet. Thank you.
Yep.
Thanks, you too. You live at the Vagabond? Go ahead and hop out when you know if you need help.
All
Before asking
suspects.
a single substantive question, the officer reads Crystal her Miranda rights. Miranda v. Arizona established that any statement obtained through custodial interrogation without prior advisement is presumptively inadmissible under the exclusionary rule. The officer gets this right completely and in the correct sequence. Everything Crystal says from this point forward can be used against her in court. The officer lays out the surveillance evidence from July 8th, matching collarbone tattoos, a membership card that wasn't hers, a bag believed to contain concealed merchandise. Crystal responds that she was heavily medicated that day. That answer is an implicit admission of presence at the scene. Under evidence law, an admission does not need to be explicit. Placing yourself at the location satisfies the presence element of the offense. The officer asks whether there is anything in the bag he should know about. Crystal discloses 2 bottles of liquor taken from this Costco. This is a post-Miranda voluntary disclosure. No coercion. No interrogation pressure. Entirely admissible. Under Nevada Revised Statute 205.0832, petty larceny applies to property valued under $1,250. 2 bottles of liquor fall within that threshold. That single statement establishes probable cause for a second charge, right there, in the back of a patrol car. The officer requests a signed complaint from loss prevention and documents the value of the merchandise. This step is not optional, it is essential. A signed LP complaint establishes ownership, the element of non-consent, and the property value. Without this documentation, Crystal's verbal disclosure alone may not be sufficient to sustain a larceny prosecution. The full case outcome was not confirmed in public records at the time of this analysis. A contempt of court warrant arising from a missed payment obligation is typically resolved by satisfying the outstanding debt. The petty larceny charge, however, supported by Crystal's own words, carries a significantly stronger prosecutorial foundation. Officer grade, A-. The detention was legally grounded from the moment of identification. Miranda was delivered correctly, completely, and before any questioning. The trespass advisement was accurate under Nevada law and reflects the kind of clear communication that reduces resistance and de-escalates encounters. One deduction, discussing the July 8th incident while Crystal was in custody, produced admissible statements that would have been better addressed through formal investigative channels, not a roadside conversation after arrest. Crystal's grade B. She remained physically compliant throughout the arrest, a decision that was both legally and practically sound. But 2 significant legal errors stand out. First, before Miranda was issued, Crystal volunteered damaging information she had no obligation to provide. Second, after Miranda, she disclosed the stolen merchandise unprompted, directly handing officers probable cause for a second charge. The right to remain silent exists precisely for moments like this. Crystal never exercised it. 3 legal lessons from this encounter. First, silence is a right, not an admission of guilt. From the moment of detention until you have spoken with an attorney, words can only hurt you, they cannot help you. Second, when lawfully detained, your only legal obligation is to identify yourself under NRS 171.123, your name and your ID. Nothing beyond that is required. Third, arrest warrants can follow from something as small as a missed court payment. Address outstanding court obligations before they become a warrant that surfaces in a public place. Let us know if there is an interaction or legal topic you would like us to cover in the comments below. Thank you for watching.